OAH is supported by the Advisory Committee to the Office of Administrative Hearings and the Commission on the Selection and Tenure of Administrative Law Judges. Based on the agency's responses to the committee's pre-hearing questions, OAH grapples with challenges, including a substantial increase in caseloads, staffing concerns, a backlog of cases, and ensuring online accessibility to cases and final orders. We will explore the agency's answers more in depth today. We will be hearing specifically from Chief Administrative Law Judge Colleen M. Curry. I thank OAH for its responsiveness to this committee's request for information. I look forward to hearing more about the agency's successes and improvements over the past year, as well as the challenges the agency currently faces, so we can help them work through and build on their foundation to meet their mission. I look forward to hearing from both our government and public witnesses today. The committee values your input. I'd now like to provide some logistical instructions for today's hearing. In addition to being in person and on Zoom, the hearing is being live broadcast at brianneknadeau.com/live. Witnesses testifying on behalf of an organization will have 5 minutes to provide oral testimony, and all other witnesses will have 3 minutes. In order to ensure we hear from all members of the public, I ask that all witnesses stick to their allotted time. For those participating via Zoom, we will be promoting you to the panel shortly. When I call your name, please accept the invitation and turn on your camera. And when it's your turn, you may unmute yourself to give your testimony. For any technical difficulties, send a message to the host, which is labeled as DC Council Committee on Public Works. They will follow up with you. Additionally, if you're having trouble gaining access to the Zoom and you've pre-registered, you can reach my team at publicworks@dccouncil.gov and they'll try to resolve your issue. So we're going to now turn to our panel of public witnesses, some of whom are in person and some who will join via Zoom. Becca Steele, Staff Attorney, Legal Aid DC. Christina Jackson, Executive Director, Washington Council of Lawyers. Christine Phillips, Chuck Elkins, Fritz Mulhauser, DC Open Government Coalition. I'll have you come and sit at the table when you're ready. And Nancy Drain, Executive Director of DC Access to Justice Commission, and Tina Nelson, Senior Managing Attorney, Legal Counsel for the Elderly. We'll begin with Becca Steele.
Thank you so much for the opportunity to testify. My name is Becca Steele, and I'm testifying in my capacity as an attorney at Legal Aid DC. Legal Aid practices at the Office of Administrative Hearings, or OAH, to help district residents obtain crucial safety net benefits, including cash assistance, food assistance, medical insurance, rental assistance, home health aid services, and unemployment benefits. For district families who cannot access the benefits they are entitled to, OAH is often the only pathway to obtaining those benefits. In my testimony today, I'll focus on a few areas that OAH should prioritize to increase access to justice, particularly for these families in need. First, OAH needs more staff to decrease backlogs and delays. Public benefits case numbers at OAH are dramatically increasing, and without a commensurate increase in OAH staff, district families are waiting longer to get their cases resolved. Many households are not receiving benefits while their appeal at OAH is pending, so delays cause significant hardship. Legal Aid is currently assisting a family who filed a TANF fair hearing request, that's cash assistance, temporary assistance for needy families, in November, but had to wait until February just to get an initial status conference in their case. During that period, the family was forced to take out a credit card and incur debt to make ends meet. These delays also bring the district out of compliance with applicable timeliness standards. Federal regulations mandate that SNAP benefit cases must be decided within 60 days. In the first quarter of fiscal year 2024, it took an average of 79 days for a regular SNAP case to be fully resolved, almost a full month longer than the 60-day deadline. In fact, it took 61 days on average in a regular SNAP case for the initial action in the case to occur. These delays are directly linked to the steady increase in public benefits cases being filed at OAH. For example, from fiscal year 2022 to fiscal year 2023, there was a 56% increase in cases involving the Department of Human Services, which involves cash benefits, food assistance, and many other types of benefits. Cases involving the Department of Healthcare Finance, which include Medicaid eligibility Medicaid coverage issues almost tripled in that same time period from 2022 to 2023. OAH needs more staff to be able to keep up with these rising case numbers, and that's a conclusion that has been confirmed by a recent feasibility study that was funded by the council. Second, OAH should promote awareness and flexibility in the method of conducting fair hearings. Legal Aid appreciates OAH's work to ensure multiple methods of conducting hearings and asks that OAH take further steps to ensure that parties are actually aware of their options and able to access them. OAH should make information on how to request a video or in-person hearing readily available on hearing forms, scheduling orders, the website, and in its offices. And this information should be translated in compliance with the DC Language Access Act. Further, OAH should increase transparency on how ALJs approach requests for in-person hearings and decide them. Third, OAH should increase public access and transparency. In particular, OAH should continue to improve the e-filing portal and work to launch its database of final orders, which is currently on track to be released later this year. Legal Aid commends OAH on the rollout of the e-filing portal, which allows parties to view and file documents related to their cases online. But the portal has not been widely used. In fiscal year 2023, less than 1% of cases had a filing made using the portal. This demonstrates the need for a two-pronged strategy. First, ensuring parties are aware of the portal, and second, ensuring they can readily access and operate it. OAH should also prioritize launching a searchable database of final orders. Releasing this information is important because it will allow parties and their representatives to determine how ALJs may consider and resolve a claim and to see how similar claims have been resolved in the past. Fourth and finally, Legal Aid appreciates that many of the requests for improvements to the OAH Resource Center have already been implemented due to the efforts of OAH and this committee. We believe the Resource Center is heading towards being a sustainable and reliable resource for individuals who are representing themselves in their OAH cases, which is common given the sheer volume of cases and the limited resources of legal services organizations. We encourage this committee to remain attentive to the needs of the Resource Center, particularly in terms of staffing, information technology, language access, and advertising, to ensure that all district families can have access to justice. I would be happy to answer any questions, and I look forward to working with the committee and OAH following today's hearing to achieve these goals. Thank you.
Thank you for your testimony. We'll now hear from Christina Jackson, Executive Director of the Washington Council of Lawyers.
Thank you, Chair Nadeau and committee, for the opportunity to speak on the importance of OAH in ensuring district residents have access to civil justice. We applaud OAH for significant progress in the operation of the Resource Center and wish to call attention to the critical need for staffing increases to ensure it has sufficient capacity to properly administer justice for the district residents it serves. OAH is an essential resource for residents who receive vital support from DC government agencies. While we usually talk about the DC courts in access to justice commission discussions in our city, it's OAH where district residents must first go to address and resolve disputes in vital service areas like access to food stamps, economic assistance, health care, benefits, unemployment insurance, education, rental assistance, and shelter. The volume of the cases presented at OAH each year is staggering. Over 26,000 cases were filed in FY23. In our view, access to justice at OAH requires increased staff capacity and other support like technology upgrades to ensure the most efficient resolution of cases before it. You have the BMC study of OAH staffing. It was in the pre-hearing materials, which specifically concluded that the agency is understaffed for its current caseload. And in Chief Judge Curry's transmittal letter, she noted that OAH had experienced a 70% increase in the number of cases filed between 2021 and 2023 and expects the increase to continue. We've included some additional findings from the study in our written testimony, but critically, the study found that OAH must increase the number of staff working directly on cases from 61 to 71 FTE and recommended additional non-case staffing. The study also assessed the implications of OAH's insufficient staffing capacity. The authors of the study found that the lack of legal assistance across OAH has impacted workload. The existing LAs are unable to keep up with the work as they're expected to lead the administrative tasks, while also researching and managing the hearings. As a result, the authors noted issues are sliding through the cracks. Further, the ALJs noted that they have taken on more administrative tasks, which takes away from hearing and researching cases. They feel they do not have enough time to properly research, set legal precedent, and manage their caseload. Taken together, this makes a persuasive case for increased staffing at OAH. DC law also requires that OAH provide public access to case filings. This is a critical access to justice issue, and we offer 2 suggestions to accomplish this mandate. A searchable database of OAH final orders published on the agency's website is necessary for litigants and their advocates to properly prepare their cases. Despite persistent calls from stakeholders for access to these orders, little progress has been made. Similarly, litigants and advocates need access to an electronic docket system for OAH cases, as you heard legal aid testify, so they can easily review their case status and confirm hearing dates. This is a standard practice in many courts and administrative agencies, but not yet achieved at OAH. We ask the committee and the council to address these areas with OAH and explore barriers to achieving these important access to justice goals. To the extent there are budget implications, either for staffing or technology, we implore the council to ensure the FY25 budget provides OAH with the resources it needs to have these services available to litigants. There's also good news. We applaud OAH for the attention it has given to making concrete and important improvements to the OAH Resource Center. As we've testified previously, 90% of litigants in front of OAH will come to the process unrepresented. This is where the Resource Center plays a critical role. The Resource Center helps these litigants maneuver through the complicated legal process they face. We applaud Chief Judge Curry and her colleagues for their attention to strengthening the Resource Center, and we are anxious to help support that work. The Resource Center assisted more than 800 litigants in 2023, and with the recent improvements, we expect a steady increase in Resource Center usage. The changes are significant steps in ensuring that the Resource Center and OAH as a whole have the capacity to help litigants who must handle these cases without assistance of counsel. We know OAH affects the daily lives of thousands of DC residents. Increased staffing is needed, ensuring the availability of appropriate technology, and support of the OAH Resource Center is vital to seeing the continued progress enhancing the capacities of OAH. Thank you for the time and the opportunity to testify.
Thank you very much for your testimony. We will now hear from Commissioner Chuck Elkins.
Thank you. I'm Commissioner Chuck Elkins, and I'm here testifying on behalf of all of Advisory Neighborhood Commission 3D. If this committee were to choose to evaluate the performance of OAH on whether they're making the best use of their resources under the circumstances, I would need to say that as far as I know, they're doing the best they can. However, if the committee were to evaluate this office on whether they are able, with their resources, to provide the services their clients desperately need, my answer would be a resounding no, and that's why I'm here today. So who are these clients that I believe are desperately in need of a larger volume of services? Some of them are the clients of the Department of Buildings. The Department of Buildings, DOB, has the responsibility to try to ensure that tenants across the district are provided with a safe and healthy place to live. They filed approximately 11,000 cases on behalf of these tenants last year. I urge the committee to examine the impact of this overload of OAH's capacity on DOB's enforcement capability and effectiveness, and therefore the people who depend on DOB for protection. Take, for example, the program designed to ensure that all tenants in the district live in safe and healthy rental units. If a tenant complains to DOB about a potential violation, DOB requires the tenant to inform the property owner to give him a chance to fix the problem. However, some property owners do not respond affirmatively to such notices, and DOB then schedules an inspection. And if the inspector finds a violation, he issues a notice of infraction. The landlord is given an appropriate time to fix the problem. But if he doesn't fix the violation, then there are no penalties. If he does fix it, then there are no penalties for the property owner. I'm sorry to say that some property owners, even given such leeway, do not restore the tenant's apartment to a safe and healthy condition. And these are the cases where a strong DOB enforcement program should bring the property owner up short, demand action by collecting a fine. However, these kinds of property owners quickly learn that they can delay doing anything until after the enforcement action works its way through OAH. And because of OAH's available resources, it takes an average of 7 months to obtain an order from OAH if the case is contested. Uncontested cases take much longer. DOB's large number of cases is in spite of great efforts by DOB to try to divert cases from having to go to OAH. They offer deferred enforcement, alternative resolutions, and actively try to identify these situations where the violation has been abated, and therefore the case can be settled without having to go to OAH. So given this situation, DOB works overtime to try to persuade the property owner to fix the problem and settle the case, knowing that the tenant is living in an unhealthy situation. This situation almost turns DOB into a free inspection program. They find a problem and beg the property owner to fix it. Property owners are required by law to maintain safe conditions in their units, but this allows dishonest property owners to wait for DOB to find the problem and then hold out another 7 months before they have to fix it. The backlog results in very serious consequences for these tenants. It's almost as if they get a 7-month get out of jail free as they continue to violate DC law. So to be frank, this resource problem at OAH makes DOB look like a paper tiger, not a strong enforcer of the law. At every turn, the lengthy appeals process of OAH forces the department to beg the property owner to come into compliance. DOB's hand would be considerably strengthened if OAH had the resources to handle these cases more quickly, therefore taking away much of the advantage of the property owner to just delay his compliance. I would be so bold as to predict that if OAH could handle these cases more quickly, its actual caseload would go down. Many of the property owners who now appeal in order to buy another 7 months of non-compliance would simply accept the fact that they got caught and have to pay the fine and put the tenant's unit back into a healthy condition. In other words, more resources for OAH would not only reduce the processing time, but might also actually reduce their workload. So who are OAH's real clients on behalf of whom OAH's performance should be judged by this committee? I believe you can safely say that some of the real clients are the tenants and the neighbors who are now living in unhealthy and unsafe conditions, who are waiting for OAH to rule against irresponsible property owners with the hope that this will persuade the property owners to bring their property back to the healthy condition required by the law. And so I therefore urge you to look at OAH in this larger context and adjust its resources going forward so it doesn't have to have such a detrimental impact on these vulnerable persons. At least maybe 11,000 last year. Thank you.
Thank you very much for your testimony. We will now hear from Fitz Mulhauser, DC Open Government Coalition, right here in person.
Thank you very much. Madam Chair, members of the committee, I'm Fritz Mulhauser. I'm the co-chair of the legal committee of the DC Open Government Coalition. We're a nonprofit community group devoted to advocacy for open government, meaning access to records, to information, to data, proceedings, and archives, records old and new. And the OAH draws our attention for the past few years because, as you've heard repeatedly, they aren't publishing their decisions in a way that the community can find them. And I'll come back to that and explain where we seem to be this year. But I echo the thoughts of the colleagues. The city needs a fast, free, and fair way that members of the community can get their concerns heard about DC government agency decisions. You've heard some kinds of public benefits and housing, but there's many more. School suspensions. Was my kid kicked out of school after the principal didn't really understand the incident? Was my taxi cab cited for an infraction by a hack inspector who didn't even look at my papers correctly? Was my trash cited for violation by the DPW 8,000 times a year when it was actually my neighbor's trash can, and so on. These are the matters, large and small, that come before OAH and need resolution. And the public wants to know, how do I file? When will I be heard? How do I keep track of my case? And what's happened to cases like mine in the past? There have been some good developments this year. They closed 18,000 cases. That's more than the entire civil division of the DC Superior Court. And they have a reorganized resource center that's helped quite a few people, and they're on track to do more. One agency with a high volume of business for OAH has started sending their tickets electronically. That's a great advance. And the filing portal you've heard of, although few are using it as yet. Most impressive, the leadership of the agency sought 2 significant outside studies and heard daunting data about the problems that the agency faces. And everyone has to commend the leadership of the agency for being willing to put on the public record information about their operations that calls for significant attention to problems. And their environment is daunting to address the kinds of problems that are in these reports. They have only 60 people addressing cases. They need at least 10 more, as you've heard. Case volumes are exploding. There are 26,000 pending cases right now. They only got through 18,000 last year. It's a recipe for delay, as you just heard very vividly. Some cases have inflexible deadlines that they can't adjust. Legislation from this council adds burdens every year. Tasks the community needs done, but which are to be done with inflexible staff. And the agencies even tell OAH when they're going to show up for hearings. This is not an environment that they're in control of. And unfortunately, they may lack the political heft to gain better relations with agencies. I spent a decade arriving at assistant secretaries' offices in cabinet agencies of the federal governments. And when I said, I'm here from GAO and I'm here to help you, that's not what gains you smiles very often. OAH's job is to say day after day, an agency made a mistake. That's a tough political environment for them to ask for more money to do more of that. The public information topic of the day is the public access to opinions. It's been talked about for years. And I put in a lot of footnotes in my testimony just so you don't overlook how long it's been. Robert White once said, I don't want to come back to another hearing and have Mr. Mulhauser tell me we don't have a plan. And so this year, the committee is hearing in pre-hearing questions for the first time that there is a contract to do a public opinion access project. We ask that you ask for the contract. I looked for it and couldn't find it in the database. We ask that you ask about the money for this. I don't see any loose change to do serious work, and the vendors' proposed costs have been a problem in past years. Ask for progress reports. It's supposed to be done this year, but that's what we've heard over and over again. And on the daunting challenges for the whole agency, we ask that you, every minute that you think about OAH, recall that fast, free, and fair decisions on everyday matters matter to everybody in the community. And you need to shield this agency from the kind of budget fracas that's ahead of us as monies shrink and needs grow. OAH, as every witness will tell you today, needs more resources, but even steady state resources require defense this year. So please help them follow the leadership of the management of the agency by admitting problems and facing them. Please stay on top of the public public access to opinions. And you did a great job with last year's budget report language, and I hope they listen again this year. And I thank you for your time.
I was going to cut you off, but then you were complimenting me, so I had to let you finish. Thank you. Thank you for your testimony. We will now hear from Nancy Drain, Executive Director of the DC Access to Justice Commission.
Good afternoon, Chair Nadeau and members of the committee. Thank you so much for the opportunity to testify today. It's my honor to testify about one of the most important fixtures of our civil justice system, which is OAH. You have already heard and understand the importance of these cases. DC residents rely on OAH to promptly correct erroneous agency decisions with their livelihoods and daily well-being at stake. We would like to highlight 3 areas that you have already heard about: the resource center, the staffing needs of the agency, and the use of technology. First, we want to applaud OAH for prioritizing the resource center that provides forms, brochures, and online resources that explain this complicated legal process to the thousands of people who navigate OAH without lawyers. This is the vast majority of litigants. 91% of them in unemployment cases, 86% in public benefits, 88% in student discipline. And while the Resource Center is not new, it has suffered from a lack of consistent and adequate staffing over the years. But under the leadership of Chief ALJ Curry, this has changed. The Resource Center now has an independent identity within the operations division, a full-time Resource Center manager with additional dedicated staff positions to come, with plans to expand virtual and on-site services and plan partnerships with legal services organizations, law schools, and pro bono attorneys. Together, these efforts are a game changer for OAH, and we applaud the agency and your committee for drawing attention to this important element of the agency. Second, we would like to underscore what you have already heard from so many, the importance of ensuring that OAH has adequate staffing to do its work. You've already heard the report's conclusion that OAH is understaffed for its caseload, a caseload that continues to increase in volume. With 8,600 cases filed in the first quarter of 2024 alone, OAH is on track to exceed its largest annual case volume in recent memory, when 33,000 cases were filed in 2019. The report describes 3 interrelated staffing concerns: the lack of a sufficient number of FTEs, low staff salaries with limited scaling opportunities that may not be competitive for certain positions, and the related retention issues that flow from each. The staffing gaps are particularly profound in the area of non-judicial support, which is critical to ensure that judges' time is spent presiding over hearings and trials, weighing and deciding legal issues, and issuing opinions. We encourage the committee to work with OAH leadership to analyze the report in light of current operations to assess what additional staffing resources are needed. It's clear from the report that OAH's staff is willing and excited about participating in its continued strengthening, but these resources are critical for them to do that. Finally, we want to highlight the important role of technology in advancing access to justice. Last budget season, the Council restored funding for dedicated IT support at OAH, but more needs to be done to ensure that technology is used effectively and that the staff are supported in using what is now available. The report urged current OAH staff to come together to collaborate around technology, but it is not lost on us that an overworked staff, hard-pressed to meet the demands on it, will find time to take on additional tasks. And this is why OAH's staffing needs are linked to its technology advancement. Technology improvements can also promote transparency. Public access reveals systemic problems that can be addressed at an agency level, like questionable policies or interpretations of existing law. Addressing these systemic issues through litigation or policy advocacy has the potential to magnify impact beyond an individual client, but public access to records is critical to ensure that work can happen. We at the Commission have enjoyed a positive working relationship with OAH. An ALJ sits on our commission, and we convene regular monthly meetings between OAH representatives and other stakeholders to foster dialogue, problem solving, and collaboration. We thank the committee for its continued attention to OAH to ensure that it meets its potential to serve the district residents and agencies who rely on it every day for help, particularly as we know a difficult budget season approaches. Thank you.
Thank you very much for your testimony. And our final witness today is Tina Nelson, Senior Managing Attorney at the Legal Counsel for the Elderly.
Good afternoon, Councilmember Nadeau and members of this committee. I'm going to sound like a broken record here, but I think it just underscores the importance of this issues that we are bringing forward to the council. Legal Counsel for the Elderly provides free, comprehensive legal and social work services to those in need, seniors in need in the District of Columbia, including housing, economic security, health and safety, and self-determination. The Office of Administrative Hearings hears many of the LCE cases, including hearings on public benefits and rental housing matters. At the beginning of the pandemic in 2020, the Access to Justice Commission initiated an OAH task force of stakeholders, including LCE, to discuss virtual operations of OAH and the impact of the pandemic on clients with hearings before OAH and a variety of public benefits, shelter, and unemployment insurance matters. The meetings gave task force members an opportunity to hear directly from the judges about changes in hearing procedures, case dockets, and staff, and to share with them our client populations issues that they face with cases heard before OAH. OAH has proven to be a valuable and receptive partner to this task force, and we continue to meet monthly with OAH staff. Several issues that the task force identified that directly impact the provision of legal services to clients here at LCE, particularly with regards to public benefits. OAH needs a significant number of new judges and support staff to adequately handle the volume of cases. A recent OAH feasibility study, as you know, concluded that OAH needs to add an additional 10 FTEs to keep up with the demand for the shortage of individuals asking for hearings in the District of Columbia. The shortage staffing issues impact Legal Counsel for the Elderly clients. OAH schedules initial status conferences 60 days out from the date of the fair hearing request. And so this causes further delays in actually getting an evidentiary hearing scheduled. Many of our clients are at risk of hunger and physical injury by the extended OAH wait time. While some claimants can claim and maintain benefits pending the outcome of their hearing, many cannot. So this impacts our clients financially, physically, emotionally, as they are left without their much needed benefits, exposing them to emergency situations. With this additional staff, there would be an almost immediate benefit to our clients who cannot maintain financial security and stable housing while waiting for fair hearings on their benefits. OAH gives parties and counsel the option to have a virtual or in-person meeting. The option is beneficial for clients with disabilities who have often challenging issues, which helps them unable to participate in these in-person hearings. However, the option to select either audio or video for virtual hearings is not communicated clearly to the public, and most hearings default to audio hearings. This is not ideal for our senior clients or other beneficiaries or applicants with hearing and other impairments. It's very difficult for parties to hear over the phone, and judges are unable to see the parties and their living conditions, which could be germane to deciding their cases, particularly EPD waiver cases. LCE suggests the option to include the request for a video or in-person hearing on the actual hearing request form and also in the scheduling order. And for virtual hearings, OAH is unable to upload recorded videos on the same WebEx system used for the hearing itself. These video recordings are stored separately. This makes it more difficult for parties and witnesses to access and review videos and other electronic evidence submitted during the hearings. The council should provide funding for a technology overhaul. LCE is very pleased, as you heard before, that the OAH Resource Center continues to operate virtually and commends OAH for making access to the Resource Center a priority for pro se litigants. However, while maintaining the virtual Resource Center is important, the digital divide is wide in the district, In-person operations are crucial to provide the public and parties with access to critical resources and information necessary for their hearings, particularly for members of the public and unrepresented parties who do not have access to appropriate technology. And finally, OAH judges are not required to publish their orders following the conclusion of a case. Published orders would enable advocates to better prepare for hearings, having had the benefit of reading prior orders, which may have precedential value on their cases. And as an interim measure, LCE recommends that OAH Office of General Counsel create a portal for advocates and members of the public to access these orders. LCE continues to be available to OAH and this committee as a resource in working towards a meaningful solution. Thank you.
Thank you so much for your testimony. I have a few questions for this panel. For our legal representatives, Ms. Jackson specifically mentioned, but I suspect all of you probably are interested in this. There's been a significant increase in the number of cases filed with OAH over the past few years. What do you all think are the contributing factors to that? Anyone can chime in, feel free.
I'm happy to provide some perspective on the DHS cases, which is one of the areas where we've seen a big increase. I think that during the public health emergency, many negative actions were suspended. So as those protections are lifted, a number of people have had issues with their benefits. And of course, all the agencies are interrelated. So additional challenges that DHS is facing that prevent them from quickly resolving cases have ripple effects that translate to cases that may have previously been able to be resolved directly with the agency, now have to go through the OAH process. So I think it's a combination of different factors, all of which unfortunately result in district residents not getting the benefits they need and then not being able to get prompt resolution at OAH.
I would add to that, particularly with regards to public benefits cases, there have been continuing issues with the Department of Healthcare Finance, particularly their assessment tool being used to determine how many personal care aid service hours an individual is entitled to under the EPD waiver program. And there continues to be problems with that system, which is requiring individuals who are beneficiaries of EPD waivers to file for fair hearings with OAH when they are getting notices that their service hours are either being reduced or that applications for the EPD waiver program are being denied. And so we think that that is also attributing to the large number of cases being filed with OAH.
And that's the EPD waiver and what else?
Yes, the EPD waiver for both beneficiaries, people who are currently receiving those benefits and those who are applying for those benefits through the application process.
And lastly,
Let me just add something as well. You should probe with the agency the questions that you'd like to get at. The case volume is enormous in the aggregate, but a huge fraction, like 80%, come from a handful of agencies.
Mm-hmm.
And so the workload is buckets full of simple, low dollar, uncomplicated matters that can be resolved in an hour or two of time, thousands of them,
Mm-hmm.
but also a few hundred, maybe 1,000 or two of very high touch, very complicated, long running disputes. If a rental housing complaint comes from all the tenants in a building, that could be dozens of people and lots of evidence and perhaps years of back and forth to resolve with well-paid lawyers from the building management. So the agency's difficulty is staffing a combination of cases that vary enormously. And that's why the staffing study, which unfortunately only had a few weeks to do its work because of procurement problems, needed to analyze very different kinds of cases and the time each of them took in order to arrive at an estimate of, do they have the right staffing? So getting the right people assigned to the cases so that they have the time needed is the huge management challenge.
Thank you.
I might just add, I noticed that there are no agencies here. And I think there's a reason for that. At least in my informal talks, I think it's because they wouldn't want to come and look like they are in any way critical of an institution that they depend on very much and work very hard to have good relations with. And yet I think the answer to your question may well be best answered by the agencies who are essentially sending these cases and who might be able in brainstorming to figure out additional ways in which this caseload could be reduced. I know they have some of those conversations with OAH, but perhaps the council would bring a different perspective that would be helpful.
Thank you. Anyone else? But we also heard from several of you an interest in technology upgrades as an area needing attention at OAH. How does a lack of technological infrastructure disadvantage pro se litigants in particular?
I can perhaps start with sort of an overview of that particular situation. So in other courts and other jurisdictions, you see an ability for litigants to be able to access information online. At OAH, for a variety of reasons, that is just not possible. And so for pro se litigants who are able to at least know, if I go here and look on this agency organization's website, I might be able to find some information, there's a stumbling block. For folks who are not able to do that, who are not technologically savvy, are not able to even come to us as organizations to ask for that assistance because that information is just not available. And so it is going across strata, across different populations, but the inability for people to be able to readily access that information, whether it's pro se or legal services lawyers who are representing clients, are making it much more difficult for the cases to move forward, are causing additional delays on top of the backlog, and are creating transparency issues that I don't think are necessarily there. Certainly OAH is not hiding things, right? But if there is not the technological ability to access them, then that also creates transparency issues, which implicates access to justice.
Two ways that I can think of. First of all, if you go to Union Station and you're looking for your Amtrak train, you want to find out when it's leaving and what gate. And you look at a handy monitor and it tells you. If you go to OAH, it used to be when you showed up for your hearing, you could see a monitor in the reception area tell you when your case was coming up and where to go. Right now, all hearings are virtual, and there isn't a shred of information online about finding your case, when it starts, what buttons to push, and so on. Most courts have electronic dockets, as was already said, but OAH can find the information to put on a board in its waiting area, but you can't find it at home. That doesn't make any sense. And second, the world is accustomed to watching 90-second videos of things to learn about new and difficult and interesting subjects. If you go on the OAH site, could you find an interesting short video about your hearing, what to expect, what you should do, how to dress, how to act? I think a minute or two would help people. But that way of using technology hasn't yet come to OAH. They have lots of words written by thoughtful lawyers to provide information, but that's not what the public needs.
Thank you. Anyone else want to chime in?
If I could just add, I think we often compare OAH to the DC courts, and we know that OAH has an extraordinarily high percentage of pro se litigants. So I think if you just look at OAH and how it functions, you have to think about it as being designed for non-lawyers, for people who don't understand how it works. And so technology can help people that are unfamiliar with a system understand it better and navigate it better, as other witnesses have described. Technology also increases efficiency. And I think that, for good or bad, if you have a lawyer and your lawyer knows how the system works, they can immediately recognize the delay and say, I should call up OAH and see what's going on, or I should follow up in some way. But pro se litigants are not able to do that. They don't feel confident about doing that. They don't even know that that's something they can do. And so in some ways, having a system that is so prevalently pro se means it should work even more efficiently than systems with lawyers, because you are going to have folks who are not empowered enough to navigate that system, which means that the technology should be even better than other areas to make sure that it's working efficiently. And so, I think we have a situation here where the agency wants to do more, they want to do better, but they need additional staffing and resources, and also need to make sure they're dispatching their own staff to use the technology that they have available to its maximum potential.
Well, thank you. Commissioner Elkins, you mentioned in your testimony it takes an average of 7 months to obtain an order from OAH if the case is contested. How long does it usually take for an uncontested case?
I don't have that figure. I just know that it's longer.
Why are they longer?
I'm sorry?
Why is the uncontested longer?
I'm afraid I don't know. I'm an outsider compared to all these other witnesses. I'm an observer of what's happening at DOB, not an observer of what's happening at OAH. But I came here because of what I saw was happening at
Yeah,
DOB.
understood. Thank you. Anyone else understand what the difference is? Any of my lawyer friends here? All right, well, that'll be a question for the agency then. Can you be specific? Can you talk more about Commissioner, about how the lengthy appeals process weakens DOB's enforcement capabilities?
Well, I think DOB would really like to be able to very quickly bring these property owners into compliance. But I think the property owners, it's a money issue, and some of them are, of course, quite do the right thing, but some of them don't want to do the right thing, or don't have the money to do it, or don't want to do it right away. And so it really, I think some of us who've been critical of how they are taking care of these tenants, which includes me, have essentially said to them, you've got to find some other solutions besides relying on OAH. This just isn't, that you need to be concerned about fixing this for tenants, that you're doing inspections is not enough. And they have taken that to heart. And so they have essentially, I'm sorry to say, have weakened their enforcement, because they basically, as I tried to say in my testimony, they try to negotiate everybody into compliance, which means they have to give away a lot. And they know that the knowledgeable property owners know that they have the upper hand because they can go to appeal. And so it's sort of a vicious circle. I'm sorry, I may not be describing it well, but it's.
No, I understand what you're saying.
Oh.
Thank you. That's very helpful. What would be the ideal time frame for resolving cases related to violations of building safety and health standards?
That to me?
Yep, to you. Still to you.
In 1 week, I mean,
yeah.
If you have a leaky roof, you want it fixed, and your kids are getting asthma because of the mold. I mean, we could all we've all heard these stories and know them. And so that's unrealistic, of course, for OAH, but I mean, my wish list would be a couple of months, 3 months even. I mean, even that, I think, as I try to say in my testimony, I think if the property owners saw that they only got a 2 or 3 month benefit, they might say, oh, what the heck? Okay, I'll do it. 7 months, boy, is that attractive. Money, and particularly at today's interest rates, they're making money off this. So I don't know if you could shoot. I don't know how one could do it, but 2 or 3 months would just be wonderful.
Thank you very much. Mr. Mulhauser, could you elaborate on the reasons behind the low utilization of mediation services by litigants despite their desire to be heard by a judge?
I wish I could. I noticed the figure in the reporting and it struck me. First of all, mediation means that someone helps two parties try to come to a conclusion that satisfies both. A mediator doesn't announce the correct result, doesn't tell people the law that should apply, just tries to find a solution. And in the comparable realm of small claims court in the DC court system, everybody has to try mediation first before you have an expensive judge on the bench hearing evidence, applying the law, and making a decision. So mediation is an attractive efficiency move to have people try to work out their disputes. And it's so attractive, especially when it's done with trained volunteers, as in the Superior Court, that it's mandatory there. So it was just striking that OAH is advertising that, would you like to have your matter mediated? But nobody says yes. So I hypothesized in my testimony, number one, I think people want to be heard. They want to be heard by a judge. Mm. And it may look like second-class justice to go to mediation. Also, the way OAH does it, they assign judges. Judge A will mediate a case, and if it doesn't work, it will be tried by Judge B, so that there's no fear of communication that will spoil a fair trial. But the point is, you're using your most expensive and scarce resource of administrative law judges to do the mediation, which is not necessarily requiring all of that judge's skills. So it's curious to me, number one, how many more customers could be persuaded to try mediation if it were explained as not second-class justice, but an attempt to solve your problem? And number two, if OAH did it with other kinds of people than expensive judges. Those are some meditations that came to me as I saw the very small number, and I said, wait, this is an efficiency approach that should be tried more widely. And it works very well for some kinds of claims. So why not?
And the mention of the final orders being public was something that came up for a number of witnesses, actually. Do you feel that we have a path forward on that?
No.
Okay. What do we need to be doing?
We need to find out what's behind the promise, which is found in the pre-hearing questions only. The council earlier urged the agency to work with the community and knowledgeable technology and court management experts in the community to talk about these plans. There's been none of that. So this was fresh to read about, that there is a contract and it will be tried out this year. But we don't know what's in the contract. You can't find it in the DC government contract portal. You can find their basic contract with their e-court court management vendor, but there's no apparent contract for new work such as was being promised. And second, what are the parameters? How was it defined? What is the system going to be? How will you be able to search? And so forth. The resources needed are completely unclear, so we don't know. For every solution that's been proposed in the past, not enough resources has always been the sticking point. So how is it suddenly we have the resources to write a contract to do something that isn't yet described? I've heard from those who work in OAH that judges are going to be trained about feeding opinions to a new system so that, for instance, confidential information isn't included in written opinions, and that's a good step. The Court of Appeals here started training lawyers to not put confidential information in briefs 2 years before they were beginning to post more information online because of the concern that lawyers even needed to be oriented to the new requirements of keeping private information out of pleadings that were going to be public. So what is the plan with the contractor? What are the resources? What's the schedule? What about the problem of looking back? The court, OAH, has said in its pre-hearing materials, we can't go back. We'll only start doing it looking forward. I haven't heard any further discussion of that, but it's not clear to me that that's impossible. And lastly, I think the council needs to keep on top of it as it goes forward this year, because we've simply heard years of promises never delivered.
You mentioned one agency sends cases electronically. Which one is that?
It's one of the motor vehicle. I think it is taxi infractions, or no, that's a separate database altogether. Their numbers are not even in the statistics. It might be some other form of, or maybe it's the DPW trash ticket set. They'll answer readily because they love it at OAH.
If I may, it is DPW.
Okay.
It is DPW.
What is very interesting, council member, is that
Thank you.
OAH is not able to tell agencies how they need to receive these individual cases. So they come in every imaginable way. I have sat in their office and watched someone come in with a cardboard box full of this week's cases from an agency. So you would think the court could tell its customers in the agencies, here's what we need from you. Let's work out electronic ways to get us what we need to go to work. But no, the agencies seem to have such sway over those parameters that OAH cannot dictate. And that's something which a deputy mayor ought to address, to say, we need multiple agencies to listen to the central panel and to tell you how to send your cases to OAH for fastest resolution. They are doing manual data entry of case information as submitted by agencies for hundreds and hundreds and hundreds of cases. That's not 21st century information management.
That's true. This is really for anyone. What challenges do users currently face in tracking their cases, their own cases? Mr. Mulhauser, you want to give it a shot?
The colleagues from Legal Counsel for the Elderly and legal aid would know this best, but an individual person who files a request for a hearing has to call up and say what's happening, because they cannot find anything about it except what's come in the mail, if their mail reached them, because there is no online access to easy case information. You have to set up an account. to file electronically, and very few people are doing that. And so I imagine people start a case however they can, and then they simply call the clerk's office repeatedly to find out stuff. That's what the Resource Center now does, is answer the phones when people ask stuff about their cases.
I would also just simply add, a lot of communication between advocates parties and OAH staff is through email. So if you have a situation where you have an unrepresented party, one, who doesn't have access to email and doesn't have an email address, then it makes it very difficult for them to maintain contact with the staff, the clerk's office at OAH, to find out the status of their cases. And sometimes the emails even sent to the correct person at OAH don't get a response in a timely manner as well. So even those clients and advocates who are able to communicate effectively through email oftentimes don't get a response. And so it requires oftentimes several phone calls to the clerk to find out what the status of the case is. And again, when you're talking about an unrepresented party who doesn't have access to an attorney to help facilitate those conversations, then they don't occur.
Thank you. Thank you very much to this panel. I really appreciate you participating in our hearing today.
Thank you so much.
Thank you.
Thank you for your time.
We'll now be joined by Colleen Curry, Chief Administrative Law Judge for the Office of Administrative Hearings. Absolutely. Take your time. Absolutely. Before you begin, I'm going to swear in you and anyone else who might be giving testimony and answering questions today. Oh, excellent. Very good. Do you swear or affirm under penalty of perjury that the testimony you are about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth? Very good. When you're ready, you may begin your testimony.
Good afternoon, Chairperson Nadeau, committee members, and staff. My name is Colleen Curry, and I am the Chief Administrative Law Judge for the Office of Administrative Hearings. Thank you for today's opportunity to testify about OAH's accomplishments and challenges during fiscal year 2023 and thus far into fiscal year 2024. I have to say that you probably will hear a lot of things that you've already heard today. There are a lot of issues that I've heard from the public witnesses that I will be addressing. OAH's operational stance remained unchanged throughout fiscal year 23 and into the first quarter of fiscal year 24. We continued with a hybrid work schedule and continued conducting hearings in most of our cases remotely via audio conference, while allowing the parties to a case flexibility to request to participate via video conference or in person. Throughout the last fiscal year, we continue to evaluate which methods best serve our constituents and make adjustments as necessary. At this time, our current processes allow OAH to meet its goal of affording widest possible access to our hearings to all communities we serve. The core measurement of OAH's workload is the number of cases that are filed with our agency every year. Prior to the pandemic, case filings had increased by 79% between 2016, when 18,537 cases were filed, and 2019, when 33,158 cases were filed. This increase resulted in a backlog of cases awaiting adjudication that OAH is still struggling to process and close, notably in the jurisdictions involving cases from DPW and the former DCRA. Although caseloads dropped during the pandemic, we have seen continued increases since 2021. In fact, OAH saw a 70% increase in the number of cases filed between 2021, when 15,400 cases were filed, and 2023, when 26,353 cases were filed. In the first quarter of fiscal year 24, 8,678 new cases were filed. At this rate, OAH is projected to receive approximately 34,700 new cases in fiscal year 24. That's more than a 30% increase from fiscal year 23 and the highest number of cases filed with OAH in any year to date. As a brief aside, I note that none of OAH's caseload totals include data regarding OAH's adjudication of Title 31 notices of infraction issued to for-hire vehicles. Those cases are adjudicated using the ETIMS case management system. The DC Department of Motor Vehicles utilizes that system the most and holds the contract with the vendor for that system. OAH is not a party to the contract and has extremely limited access to data from that system. Managing this increasing caseload requires two things: working more, that is increasing the number of FTEs, and working smarter, that is better utilizing existing technology, employing new technology to incorporate efficiencies in processing. To evaluate how best to manage our workload, OAH undertook 2 studies in fiscal year 23, a rapid technology assessment performed by Mondrian Consulting in February of 23, and a staffing benchmark study performed by B. McNamee Consulting in August and September of 23. Mondrian Consulting itemized and evaluated the multiple technological applications and systems OAH uses and the processes OAH employs to accomplish necessary tasks. Its final recommendations are summarized as follows: streamline and automate internal processes, integrate internal systems to the greatest extent possible, create interfaces between OAH's case management system and those used by the district agency whose cases OAH hears to automate data entry to the greatest extent possible, and encourage increased usage of the e-filing portal. B. McNamee Consulting examined workload, evaluated existing business processes, performed a time study, and identified inefficiencies in OAH's business and technological systems. BMC made 5 strategic recommendations: move to a preferred culture through relationship building and improved communications, reshape staffing to meet caseload fluctuations and agency changes, nourish a talent pipeline for retention and efficiency, implement lean process improvements with technology, people, and processes, and enhance relationships and communication with other district agencies while maintaining independence. And I feel like a bit of a broken record, but 2 central conclusions from OAH that we learned from the BMC feasibility study are: we are understaffed for our current caseload, and we need to integrate and better utilize technology. In terms of staffing, as I reported at last year's performance oversight hearing, OAH experienced vacancies in 17% of its locally funded FTE positions at the end of fiscal year 22. At the end of fiscal year 23, 24 of OAH's 96 locally funded FTEs were vacant, a 25% vacancy rate. Now, some of those vacancies were the result of budgetary constraints, but since the pandemic, OAH has had difficulty recruiting and retaining new staff, particularly support staff who work directly on cases despite rigorous recruitment efforts. In its report, BMC observed that these difficulties and the resulting FTE vacancies, combined with increasing caseloads, have, and I quote, created the conditions where employees are unable to maintain standardized processes, provide necessary training and professional development, adopt and properly incorporate technology into operations, and an overall breakdown in working relationships. BMC believes that the longer these conditions persist, employee retention and court operational efficiency will worsen, and I end quote. OAH, however, has remained focused on successfully executing our mandate. That is, to adjudicate these cases brought before us as efficiently and fairly as possible, with the broader goal of providing the best possible service. To meet our mission, OAH works to ensure equal access to our hearings, continues to identify ways we can remove barriers to broad participation in those hearings, and remains attuned to the needs of the communities we serve and adapts to those needs where possible. We remain mindful about stewardship of the public resources entrusted to us and engage regularly with our stakeholders, including the mayor and the city council, to respond not only to their concerns, but also to the needs of our litigants. Based on the conclusions of these reports, OAH has taken multiple steps or expanded current projects to improve agency efficiency and morale, including scheduling regular cross-cluster, cross-discipline, and all-agency events, evaluating processes to identify opportunities for increasing efficiency, monitoring caseload on a monthly basis, developing standard operating procedures within and across clusters, creating consistent and in-depth training for new employees and refresher training for existing employees, and expanding interagency communications. In addition, OAH has identified multiple ways to streamline processes, both internal and external, and integrate technological systems. But effectuating these efficiencies will require financial investment and training. We are doing what we can with our current technology, but that will only take us so far. In spite of the challenges of the last fiscal year, OAH has achieved some notable milestones and successes. First, OAH completed the rollout of the e-filing portal. This portal allows registered users to electronically file new cases in certain case types and to file additional documents in all case types. It is important to note that OAH received over 115,000 filings in fiscal year 23, the vast majority of which were received via email. Less than 1% of the filings were received through the e-filing portal. OAH is currently evaluating how best to expand use of the e-filing portal to increase online access for litigants and to increase efficiencies in processing these documents. Second, OAH is contracted with our case management system vendor and has begun work on constructing a platform for the public to access OAH's final orders. That work is in progress, but we fully expect to begin testing the system by the third quarter of fiscal year 24 and to begin publishing final orders to the web by the fourth quarter of fiscal year 24. Further, OAH's revitalization of the Resource Center has continued steadily, including in October of 23, we hired a legal resource center manager. 3 additional FTEs are assigned to the Resource Center. OAH is currently recruiting for a Resource Center coordinator and a program analyst, and written intake procedures, volunteer agreement forms, and training reference manuals are being created to lay the foundation for increased capacity for the Resource Center. Ms. Chairperson, thank you very much for your time and interest in OAH. In closing, please allow me to publicly thank those who are most instrumental in helping me prepare for today's hearing. Chief Operating Officer Lachelle Jenkins, General Counsel Smruti Radkar, Administrative Officer Nicole Green, and Staff Assistant Joseph Mangan. I also would like to extend my sincere gratitude to the staff at OAH for their steadfast commitment to administering justice on behalf of the residents of the district. I'm happy to answer any questions you may have. Thank you.
Thank you so much. And you started introducing the folks who are with you, so let's just make sure we get on the record.
Chief Operating Officer Lachelle Jenkins.
Good.
And would you?
Shelley Robinson Graham. I'm the Cluster Budget Director for Public Safety and Justice.
Very good. Thank you very much. Thank you for your testimony, Judge Curry. I am going to ask my questions in the order of the topic sections sent in the pre-hearing questions to keep things organized and hopefully make it easier for you all to respond. I'm going to begin with an overview of the agency's organization and staffing. First, how many total employees work at OAH?
We have 96 local FTE positions and 20 interagency positions.
And how many non-ALJ positions are vacant?
Non-ALJ positions, 24 local and 2 interagency.
In your response to question 2 of the pre-hearing questions, you indicated that Department of For Hire Vehicles and DPW were separated from the license and enforcement cluster. What is the license and enforcement cluster?
Our staff and ALJs who hear and process cases are divided into 5 different clusters. Because we have such a vast majority of different types of cases that we hear, in 2016, instead of having all judges and all staff handle all cases, we were divided into those different clusters. And so they are different types of cases that are similar. So the licensing and enforcement cluster are ALJs and legal assistants in the clerk's office that focus on cases involving licensing and enforcement issues. So for the enforcement issues, DPW, the former DCRA, DOB, licensing, DLCP, we have the Office of Tax and Revenue, Office of Planning, Department of Health. So there's a wide variety of clusters. We also have the rental housing DCPS cluster. We have the employment cluster, unemployment insurance cluster, which is just unemployment insurance because those are very unique cases. We've got the public benefits cluster and then compensation, which is workers' compensation, paid family leave, and wage out. So the licensing and enforcement cluster became unwieldy.
Mhm.
The vast majority of our cases are licensing and enforcement cases. Our two largest filers are DPW and the former DCRA, DOB. And because of that, we started assigning a long time ago, DPW is assigned to all staff and all judges. So what we did is we cut out from licensing and enforcement those cases that were assigned to all staff and all ALJs. In particular, DPW and the Title 31 taxi cases. So we have a structure in place to manage just those cases that are assigned to everybody. So that's the licensing and enforcement cluster, and then the DPW, why we broke those out.
So DPW then goes to everybody.
DPW is heard by all the judges and all staff manage those cases.
Okay, this is all sounding familiar, I think, from the staffing study. So,
Yes.
okay, very good. And I see that you also converted the Deputy General Counsel position into the Legal Resource Center Manager position during the FY23 budget cycle. How has that affected the operations division?
Well, in an effort to lay the foundation for a more robust resource center, we believed it was necessary to create a supervisory position that would manage the resource center staff separately from the general counsel's office. And so we cut it out in order to create that position so that we could manage it. The resource center manager reports directly to our chief operating officer.
Do you intend to hire a Deputy General Counsel as well?
At this time, no.
The agency deactivated 3 administrative law judges due to interagency budgetary constraints. The reason cited was PFL funding from DOES not available in FY25, can't hire in FY24. When were these positions deactivated?
In beginning of fiscal year 24.
And were there any remaining funds at that time for those positions?
So by statute, OAH receives 0.5% of the paid family leave fund every year. And the amount of the paid family leave fund was reduced dramatically in fiscal year 23. And then again in fiscal year, it has stayed low.
Mm-hmm.
The amount of funding that we received, therefore, did not support hiring to fill those positions. And ALJs are hired for an initial term of 2 years and then reappointed at their request for, there is a reappointment process. An ALJ can request reappointment. The reappointment term is 6 years. And so there started to be anti-deficiency concerns in if we wanted to hire for those positions, especially when the funding was going.
Has that impacted the ability to adjudicate paid family leave claims concerns?
No.
Okay. Last year, my committee staff met with some OAH union members of the DC chapter for the Federation of American Law Judges. This was regarding the compensation scale. Basically, the ALJ pay scale isn't keeping up with the competitive pay and overtime. And the issue is that the minimum compensation for ALJs on the ES10 pay scale is not competitive with median compensation of attorneys on the LX2 pay scale. The union members expressed that it's becoming more difficult to attract and retain ALJ talent. Do you agree?
No.
Do you want to expand on that at all?
We've never had a problem attracting highly qualified applicants for ALJ.
The issues you're having are regarding the support staff?
Yes.
Why do you think you've never had an issue recruiting or retaining the ALJs?
Personally, as being hired as an ALJ at the beginning, it's a great job.
Yeah.
It is, a lot of people see it as a stepping stone to Superior Court or the federal administrative law judiciary. And it's a well-paid job. So.
Can you elaborate on any specific challenges or priorities that were addressed with the union negotiations for the FY24 agreement?
Not at this time. I'm happy to follow up if you'd like.
What specific actions are being taken to attract and retain ALJ talent?
We don't have any vacancies at this time. And usually the last vacancies have been because ALJs have either gotten positions with Superior Court or federal ALJ, federal administrative judiciary, or have retired. So when we have a retirement, the Commission on the Selection and Tenure of Judges asks us to post the position. We have traditionally posted it on the DC website, DCHR website, but this past year when we had vacancies, we reached out to the DC Bar and reached out to the affinity bars associated with DC Bar to try and cast a much wider net.
Great. Given the urgency highlighted in the reports regarding technology incorporation and workplace culture improvements, what specific steps is OAH planning to take to address staff turnover and retention among the sports staff?
We're doing a lot of things to try and improve morale, vigorously fill our positions. We're doing a lot of recruiting. That would go a long way at 25%. That's a lot of vacancies, which shifts that burden of work onto others. I think that filling those positions would go a long way. Another thing that I think is a problem that we're exploring is that our legal administrative staff is not necessarily paid very well. And that's a function of the pay scales that are applicable within DCHR. So we're looking at ways to try and accommodate changes to help that.
And is that something that DCHR has to sign off on?
Mm-hmm. We do not have independent personnel authority.
Mm-hmm. And those positions don't have leeway within their salary bands at all?
Not at this time, no.
Yeah, okay. Is there a way the committee can assist with those conversations?
Let me think about that and we'll get back to you.
Okay.
Thank you.
Sure. Right, so moving into budget, spending, contracting, and procurement. For FY23, the Information Technology Services General Division had a significant budget reduction from $447,541.52 initially to $210,000 revised. Can you provide an explanation to the reasons behind the reduction?
Sure, that reduction was part of the mid-year fiscal year 23 agency budget reduction requested by the mayor and approved by council.
Yeah, okay. So reprogramming. For FY23, the grand total indicates a budget of $11,991,337.24 with actual expenditures of $11,174,168, resulting in an available budget of $522,224. Was that reallocated to FY24?
So surplus, is this on?
Yes, it is.
Oh, okay.
When it's red, you're on. It makes no sense.
Okay, all right. So what you're reading was the gross. So that
Okay.
was like local, that was the, federal payment. So if we want to just talk about any local versus non-local. So, the surplus is end up just going to the bottom line. So you know how local works and
Yep.
yeah.
Okay. I see there is an FY24 intra-district transfer from Public Safety and Justice Agency. What's the description of services to be provided for that?
You're asking about interagency activities.
From Public Safety and Justice Agency? There was a transfer.
So there's just several interagency agreements that OAH has. So say there's some with DCHR, there's some with, OCTO for telecom services. There's some for sign language. Was there any specific one? It's sort of a laundry list that's about $60,000, which is the normal annual agreements.
Okay, understood. Thank you.
Mhm.
Let's move on to reprogramming. Judge Curry, I see you attended a conference called the Central Panel Directors Conference in Seattle, Washington last year in September. Can you speak on that conference and what you learned?
Yes, the conference is a group that is so there are approximately 21 to 25 central hearing panels across the states nationally. That's OAH is a central hearing panel. We are an independent agency that hears cases from other agencies. And then the directors get together every year. This was the first year that I attended to talk about issues that face central hearing panels, to talk about budgetary issues, to talk about staffing issues, to share ideas about how they're managing technology, how they're managing case influx, and to share ideas and get some really basically talk about what we do. It was a real eye-opener. It was a wonderful conference, learned a lot about how the other OAHs, most of them are OAHs, how the other central hearing panels manage significant increases in caseload, how they're managing, what case management system they're using, whether they're publishing things to the web, so how they're doing that, how they're managing their staff, how they're training their staff. So it was really, really helpful to get ideas from other central hearing panels.
Sounds like it would be.
It was really great.
I noticed that there was a $636,448 FY24 supplemental reduction. Could you provide more details about that reduction? Where it came from?
That's great.
That for 2024?
Yes.
Because we haven't had any reduction exercise in 2024.
Okay. All right, we're going to come back to that because we're having technical difficulties up here, which is one of the themes of this hearing, isn't it?
Yes,
Technology.
Technology.
There you go. I'm going to skip some of the budgetary questions for now because guess what? We're going to get to do that again very soon. How long did it take to procure a vendor for the court feasibility report for your benchmark staffing?
We started in December. I think it was in March when we finally issued the first procurement request. And we went all the way through that. And then there was a protest and OCP had us posted again. End of July, beginning of August, when we finally procured a vendor. It's at 8 months.
And who was the vendor?
BMC Consulting, B. McNamee Consulting, sorry.
When did they begin the study?
In August. I believe our kickoff was August 11, but I'm not completely sure about that.
How long did it take?
They completed the study and provided us with their final report on September 30th.
Just in the nick of time.
They knew they had to do it by the end of the fiscal year.
Yeah, if they wanted to get paid,
Right.
which everybody does. And I noticed the agency exceeded the spending target allocated for compliance with small business enterprises. That's good. The agency reported its total percentage spending on small businesses in FY 23 was 129.19%. So I want to recognize the agency's proactive effort to support and engage with small businesses. Great job. Related, one thing stood out to me on the P card expenditures, a charge of $249.99 at the Gospel Spreading Bookstore, which is in Ward 1.
Mhm.
Was that a resource document?
Nope, that is. No, that's judicial robes.
Robes are from there.
We, I think, have they closed? Yeah, we cannot obtain robes from them anymore, so we use online vendors now.
Oh, okay. That's a fun fact, though.
Yes.
That's kind of cool. Okay. Priorities and performance questions for you. So I want to move on to that. And so staff recruitment and retention seems to be a major weakness for the agency, which seems to be a problem that grew during COVID. The benchmark study highlighted how vacant positions led to increased workload on employees. You mentioned this in your testimony. Before we delve into some of the deeper issues identified, what are your overall thoughts on the study and its recommendations?
Beyond what I said during my testimony, I think it had some really, really useful things in it. In the letter that I wrote to you when I sent you the study, I outlined some concerns that we had about it and our takeaways. So I think it's very, very useful. It definitely underscored something that we had a supposition. Our hypothesis was that we were understaffed.
Mhm.
And it definitely underscored an answer to resounding yes, we are understaffed. And it combined with rapid technology assessment really underscored another thing that we hypothesized was we have all these computer systems and they don't talk to each other and we're doing a lot of things. We still do a lot of things. Let me back up and say, we've always wanted for at least 10 years, maybe 15, OAH has been trying to go paperless. Well, happens that the pandemic occurred. So a lot of what we do now is paperless, but a lot of our processes are still paper-based.
Manual.
And data entry is one of those things that is manual and it consumes a huge amount of time. And it just underscored the need for us to figure out how to step away from that manual process, to automate a lot of our systems and to interlace a lot of our systems.
What kind of conversations have you had over the years or recently with Octo about the ways the systems don't communicate with each other for your client agencies?
Our systems are not managed by Octo. So we have our independent systems. And I don't know how involved Octo was when we created the interface between DPW and our case management system is eCourt. So I don't know how much Octo is involved on that, but our vendor is the one who really was instrumental in helping us create that interface along with the vendor that DPW was using. So, we had two agencies and two vendors that had to coordinate what we wanted to do and how we wanted to do it. So it was a complicated process. I can tell you that we started that process in 2010 and it went live in 2020. So there was a lot going on there.
And we can't wait that long for the rest.
No.
Do you think there is a role for Octo to come and help make this work?
It's something that I think we have conversations about, and we're certainly open to that.
Yeah.
When we will explore it, yeah.
Otherwise, what do you think the path is forward? I mean, would you have to go agency by agency?
Because every agency has a different case management system, unfortunately, I think so. One of the things, we basically have we have a wonderful e-filing portal. It's incredibly underutilized. And I know that some OAHs use a portal like that for agencies to file
Mhm.
cases. So philosophically, we have two options. One is to create this tunnel in between their case management and our case management, and the other is to figure out how to use the portal to do that, because
Put it
that
on them.
structure is always there, and put it on them.
Tell them
That's
they
a-
have to use the portal, and then if they want a tunnel, they have to build it.
That's a conversation that we have to have with each of our agencies. So I do want to say that we have started having conversations with DOB about building some sort, how we can more effectively transfer data.
This is interesting. Any conversations at the city administrator level or with the mayor?
We haven't gone there yet.
Okay. The study also emphasized many employees expressed that they had a favorable working relationship with the court leadership, but that they did not always feel connected with the court. This was manifested through a lack of understanding of the work, the decisions made by the court, and the overall communications between and among employees. Could you provide insights into the specific factors or circumstances contributing to employees feeling disconnected and lack of understanding of the court's work and decisions?
I think a lot of that has to do with the pandemic and our status as 100% remote work for as many years as we did. I think that's the primary factor. I've heard again and again from staff and judges that they really feel like they don't know who the person is because they never see them.
Mm-hmm.
Same time.
How do you think, what do you think is the best way to address that, to rebuild that?
We're doing a couple of things. In particular, we're trying to make sure that we have, as I testified, interdisciplinary cluster meetings and all staff events. We're planning on our first ever all staff retreat in April, to bring everybody into the same room and talk about how, who does what and how they do it, and address some other issues agency-wide. Try and improve that culture and that connection.
You have talked about efforts to vigorously recruit and fill vacant positions. In the meantime, what strategy do you have to support current staff working on the existing backlog of cases?
Well, that's one of the things that we use with our contractors. Contractors are hired to do the manual data entry, so that frees up our full-time employees to do the more complicated work. We also train some of them to do more of the basic repetitive work. That's trying to support them in that way.
Could you elaborate on the outcomes or expected results of your recruitment efforts? And you talked about your December 2022 DCHR job fair
Mhm.
specifically. Can you talk about that?
We expected to and filled 3 vacant positions out of that job fair.
Right. Is that supposed to say 2023?
That was December of 2022, so
Oh.
it was in fiscal year 23.
Got it. Uh-huh. Okay.
Yeah, that calendar year, fiscal year thing.
I know. Gets me every time. Okay. In improving hearing room technology, how has the agency balanced the need for modernization with ensuring accessibility for all participants, including those opting for remote, hybrid, or in-person hearings?
We are exploring ways to expand the use of or knowledge for everybody on how to access or request video hearings, and in-person hearings. In terms of hearing room technology, specifically the technology that was in the hearing rooms is extremely outdated. It doesn't necessarily work well with the platforms that we use. And so we're working hard to make it much more accessible for the judges, which makes doing the work of the hearings easier. Right now, our hearings are conducted by WebEx unless you are in an in-person hearing. We have a specific hearing recording platform that was contracted for, and installed right at the beginning of the pandemic. And so I think, things have changed in the last 4 years, and we need to evaluate what the best path forward is.
And is there a budget for that, or is that?
We've asked for an enhancement of $198,000.
Well, look at that. Okay. The agency have a manual of standard operating procedures.
We have multiple clusters of standard operating procedures depending on what cluster you're in and whether you're in the clerk's office or are a judge. We have bench books. We're working to consolidate and really sort of expand those because that certainly will help with training and refresher training.
So we did back to how cases get into your system.
Mm-hmm.
Do you have any authority to say to an agency, you must transmit cases this way, in a particular way?
I'd have to look into that. Don't know if we have the authority to do that. I will say that right now we receive pleadings in, I think, 5 different ways. The vast majority of which are by email from the pandemic before it was in person and by USPS. OAH created the e-filing, the email portal, the way we can receive things by email as a first step towards allowing online filing of stuff, of papers and pleadings and new cases. The shift to the e-filing portal is the first step that we're taking to try and shift that away from email. It's new. I understand that it's not as used as it would like, and we are exploring ways to expand the use of that, make it more publicized, do outreach. Website has it out there. Shift in our orders to emphasize that you can use it, things like that.
When a resident files an appeal, how long does the agency have to produce information on their end?
I'm not sure I understand your question.
So how long does it take, like, the file box to get to you after? So let's say I'm going to file an appeal. So I do my end in the portal as a resident.
Mm-hmm.
When does the rest of the information get entered by the agency or sent to you by the agency? Or is that not how it works at all?
Yeah, that's not how it works.
Okay.
It depends, and it really depends on what case type.
Yeah.
Right. So for example, our rental housing cases, those are actually filed with the DHCD. Once it's filed at DHCD, they assign a case number and transmit it to us.
Okay.
So those cases are actually filed at the agency. And unemployment insurance cases, we don't necessarily get anything from the agency unless it's filed as an exhibit that's going to be used during a hearing. All of the information comes from the party filing the claim.
I see.
So every different case type is different. The enforcement cases are the ones that we get from the agency.
Because they've got to defend.
Right, because
they've
they're
got
seeking a
exhibits.
fine from another party, so they're actually the petitioner seeking a fine from a respondent.
Oh, I see.
Right, and a lot of times, unfortunately, we actually get a response from a respondent before we get the original filing from the agency. So
That's interesting.
Yeah, so there's a lot of conflict there, but so for example, DPW issues a notice of violation, it comes through the portal, a case is created automatically. DOB, they issue their notices of infraction, and then at some point it gets emailed to us.
That's the part I'm wondering about. Like, what's the lag between an NOI and then a case getting emailed to you?
And that I would have to look at some data to try and figure that out.
I'm only asking, not because I need you to go look at the data and figure it
Yeah.
out, but I'm only asking to try to understand, like, what are the access to justice issues with things not being electronically filed the way DPW does it?
I think it's mostly the delay in getting the filings to us and then the data entry. I mean, if you go back to the number of cases that we saw filed from the former DCRA and then from DOB since the split, the number has exploded. And there's only so many people we have doing data entry on those
Yeah.
cases.
Well, and it's also
so-
because they changed their flow too, right? Because they used to have sort of a two-part
yeah.
NOI, NOV thing, and now it's all like
Yeah, well,
one.
and NOIs and NOVs vary wildly from agency.
Right.
They're different. DOE has different ones, and DOE has different ones, DLCP, DOH, that very different. So every single one has to be handled differently.
Yeah. And then how long does it usually take from when OAH receives those materials and it's entered manually into the system?
And again, that varies wildly depending on the case type. Unemployment insurance, that we usually within 2 days,
Okay.
2 business days.
Okay.
DOB, I'd have to go back and look, but I suspect it's longer because so many cases
Right.
are being filed.
And those are still within a cluster, the DOB cases?
DOB are in the licensing and enforcement cluster. I will say that because we had a backlog of cases that were awaiting adjudication of admit with explanation cases, we started sharing those with all of the judges to try and get those backlogs.
Mhm.
So until we're caught up, all of the judges are taking a few of those.
A few of the
to
DOBs.
Yeah. But those are not the ones where the claim is denied and we have to have a hearing. Those are paper pleadings only.
Mm-hmm. And if somebody's calling for the status of their case and it's a period of time, either the agency hasn't transmitted or it hasn't yet been entered, what do they find out when they call?
It's not in our case management system.
Yeah.
So we don't unfortunately have any information about it.
That's what I would expect, obviously. I mean, you don't have it in the system. It's not something someone can pull up. But it does seem like, you know, that's not where we want to be. So I definitely want to keep thinking through with you
Mhm.
how to approach, especially just the transmission of cases. I know we want everything to be electronic, but I mean, it's not only an access to justice issue, it's a staffing issue, it's a morale issue, clearly.
it's
Nobody
very-
wants to be doing that data entry.
It's very interesting. I mean, this is one issue that touches so many other larger issues in the
Yeah.
agency, and figuring out the best path forward has been a challenge.
It really is the kind of thing where I just want to, like, seriously just go march into the mayor's office and be like, can you please solve this? Because these are all your agencies and it, you know, but that's not really how it works. And obviously you are in charge of this one, so I will allow you to proceed the way you want to proceed for now. But I think that, given that Octo is in this committee and, they are meant to be serving all of our agencies, even if their system was not created, your system was not created by them. They're going to have to be involved in any solution where vendors are bumping data, I think. So, and I do think that gives us a little bit more assurance on things like data security and things like that when they're involved, because then it,
Mhm.
you know, you're not out there on your own. So let's talk more about that.
Okay.
Okay. Let's see. Your pre-hearing answers indicate that OAH issued sanctions in 11 cases in FY 23 and 24 to date. All 11 cases were against the Department of Human Services. Could you elaborate on the nature of the sanctions imposed and the specific circumstances that led to their issuance?
There was, and I think one of the public witnesses testified about this. There was a glitch in their computer system that prohibited them from implementing rules from OAH, awarding or reinstating benefits to claimants. And sanctions were for failure to comply with the ALJ's orders, instructing, awarding either reinstatement of the benefits or continuation of the benefits.
And OAH doesn't typically track this type of information?
No.
Why not?
That's a data point that we don't keep track of in our case management system.
Do you think it's one that is important to track? Does
Well,
it come up much?
Let me think about that.
All right. My prompt says that I'd now like to discuss court technology, but I think we both know we've been talking about that for a while now. Okay. Let's see. FY23 included funding for a study to perform a technology assessment. That's your rapid technology assessment report. And it concluded last year with recommendations. Let's see, anything else you want to add about how you're implementing recommended changes on that?
I think I've covered a lot.
Yeah, I think you have too, but didn't want
I
to.
could repeat myself if you'd like.
You do not need to. I just want to make sure we didn't forget anything. One of the report's findings did show that the agency's paying for an overlap of services for hearing room, audio, and visual recording systems. Can you elaborate on the specific services covered under the remote support? I could read you the invoice numbers, but I think you probably know what I'm talking about. Do you want me to read you the invoices?
So this is regarding the digital court recorder, the recording system for the hearing rooms that we installed to replace For the Record, which was our prior recording system, which was not supported any longer and was failing at a very scary rate right before the pandemic. We realized, and so the remote support is them coming in to help us if we had an issue with the recording system. And we realized that the vendor had double charged us, and we abated the smaller, I think it's $1,650 invoice. So we didn't actually pay double.
Got it. How closely is OAH working with BIS Digital to address oh, you just told me that. Okay. Let's walk through the agency's use of eCourt case management software system. I see that. All right. So DPW is the only agency that has an API set up. Is that right?
Right now, yes.
Okay. I like the optimism.
I can always be hopeful, right?
All right. I think we've covered a lot of this. But just to make sure that I'm clear on the process, I know you and I've talked about this in the past to make sure that we can advise constituents appropriately. A person receiving a ticket from DPW has three options: pay the fine, admit with explanation, or deny. Is that right?
Correct.
Okay. If there's no response after 19 days, the fine doubles. And if the person still hasn't responded, an ALJ declares them in default and imposes a penalty.
Correct.
How does the agency ensure the accuracy and completeness of the information in the notice of violation tickets entered into eCourt?
When the default is entered, there's the case record to make sure everything's correct.
Another manual review, huh?
Yep.
No, that seems like an important
For
one
DPW in particular, let
Yeah.
me say that the data comes directly from DPW.
from them. Yeah,
So we've pretty much eliminated the data entry errors.
right.
So the number of, unless the information on the NOV itself is wrong or is incomplete. And that's not something that we would be able to verify one way or another.
I see.
So the system is it's a lot cleaner now.
Makes sense. And what steps are taken during the 19-day period or additional 10-day grace period to notify individuals about their tickets and the potential doubling of fines if there is no response?
I'd have to look at the NOV, but I believe that the warning, the information, all that information is contained on the NOV.
Yeah.
So they're warned of that in the once it's served on them, if
Mhm.
they actually read it.
Right.
And then a default, a final order by default is issued and sent to the address of record. And at that point, if they disagree with it, they can also always ask for reconsideration.
Okay. And there's I just want to make sure I understand this. So there's a process of reviewing cases for missing information before DPW sends them to OAH? No. Okay.
At least I don't know how DPW does it. so-
Correct. That's not to you yet. Okay. And then is OAH staff manually checking for tickets without responses?
We have to search for those cases in eCourt, and there are a couple of searches that we have to identify those cases. And
Okay.
then we have to manually process. One of the things that we're working with our hopefully working with our vendor on is creating an automated process for us.
Okay.
So there are a lot of automations in eCourt that are possible that we're working on building to try to make the work that's done more efficient.
Great. Okay. In your pre-hearing responses, I see that SNAP fair hearings are exceeding the 60-day deadline required by federal law. What is OAH doing to address those delays?
We've dedicated additional resources to try and manage the increased requests. Let me just say that it's primarily due to two reasons. One, sometimes we don't get the hearing request transmitted to us immediately upon filing from the other agency, so there's a built-in delay there. The appeal request is filed with the agency, they transmit it to us, and we don't get it for a period of time. So that's a built-in delay there. And then also, and I think one of the other public witnesses talked about this, we saw a very sharp increase in the number of hearing requests in fiscal year 23 related to the end of the public hearing emergency, or the public health emergency, pardon me. And so in response to that, and we knew it was coming in anticipation of that, we were trying to shift additional resources to manage the increased requests. So don't have enough staff to do the work that we need.
Do you think that bump and backlog will flatten out? Or do you think it's here to stay?
I don't know the answer to that question. I need to talk to some other people who are more hands-on with that. I'm certainly happy to follow up if you'd like.
Yeah, I guess I'm just curious, if it's like, okay, we've got to get through
Yeah.
what happened at the end of the public health emergency, but now we're leveling out.
Mhm.
And when you say you're not always getting the transmission from the agency timely, would that be DHS,
I think so.
SNAP?
Yeah.
Okay. Talking about DOB a little bit more. We heard from the commissioner. He said it takes an average of 7 months to obtain an order from OAH if the case is contested. Let's just verify that's what your experience is as well, or your data shows, but also, how long does it take for an uncontested case? And you might have heard my question, wait, why does an uncontested take longer than a contested?
And I don't have the data in front of me, so I
Yeah.
can't speak to how long on average for DOB cases to get a hearing. And I can tell you though, that the backlog of cases that we have related to DCRA, the former DCRA, now DOB, the backlog that we're processing now is all cases that we didn't get a response in. So the cases that where we have a response, somebody has either requested a hearing or filed an AWE, we're much closer on those than we are on the ones that are waiting default. And we are steadfastly working through those. I don't have the numbers right in front of me, but my looking through the pre-hearing responses as we were putting together, it looks like despite the increase in cases that we saw, the number of backlogged cases is relatively the same. So the proportion of cases that it's coming in is greater than the proportion of increase in default cases. So we're doing good work. It's just, again, We have staffing issues, and that feeds into this.
Is the non-response the same thing as uncontested?
That's the only thing I can think of. A non-response would be uncontested.
Okay.
Um,
And that means that, for example, a landlord hasn't replied?
Well, the respondent has not filed an answer. Uncontested is also somebody who just pays.
I
Right.
see. I see, which presumably isn't what's slowing things down.
I wouldn't think so.
Yeah. That
And,
seems-
and we don't receive payments on DOB cases.
They go to the
DOB has a-
agency.
DOB
They
has
have
a
an
payment portal. Yeah.
Yeah. SP. Excuse me. Okay. How many judges work on DOB cases?
Ask me a question and then the answer just goes poof.
It's okay.
It's either 11 or 12.
Okay.
But then all of the judges hear a portion of them.
Okay. We had some good testimony about the potential of mediation. What do you think is behind the low utilization of mediation services?
I really don't know. I think it was Mr. Mulhauser's supposition that parties want to be heard. I do want to say, though, that the majority of the mediations that occur in our agency are done by ALJs.
Hmm.
So all of our ALJs and all of our general counsel's office are certified mediators. That's one of the trainings that we provide for newly onboarded ALJs and newly onboarded in our general counsel's office. So everybody is certified to mediate cases, but there are a lot of cases where we cannot by statute mediate,
Mhm.
and a lot of cases where have in the past figured out that it's not worth it. A lot of time in attributing to trying to mediate a case with of cases that are actually settled, it wasn't worth it, but
Mm.
mediation is always available and encouraged in several types of cases.
Okay, that's good to know. And maybe we need like a poster that says like mediation, you still get a judge or something like that. Let's see if it helps people. Okay. Let's talk about the searchable database of final orders. What year does the oldest final order date back to?
OH has been in existence since 2004, and the pilot project was started in 2002.
So you think there would be final orders back from '02, or would they not count?
At this point in time, our plan is
Is it
to,
relevant?
our plan is to, well, a lot has changed since 2002.
Fair enough.
Our plan is initially to start with a date certain and move forward. There are a lot of factors that go into that. And once we get the system in place and once we get it working and functioning, then we can go and look back at whether it's possible, and if so, how to start converting these old orders. Because so many of the orders have to be redacted.
Right.
Every case type has some level of redaction by regulation or statute. So every single case type has to be handled slightly differently. And our official record, eCourt is tantamount to our official record. And so we have to keep an order that's not redacted in the official record and use a different form of that for a redacted order that goes that it will be publicly available.
So even moving forward, is there a lot of manual work to put cases in, or is there software that does that?
There is going to be manual work. There's no way around it.
Mr. Mulhauser talked about training attorneys to write supporting documents that don't have as much personal identifying information. Is that feasible for this sort of process?
Well, our attorneys don't write our orders.
Right.
So, and we are in the process of working with the judges and our general counsel's office is working with the judges to create a basically a manual on how to redact a case. So you have this type of case, this is the data that needs to be redacted. And if you look at that in advance and you're writing an order, you can say, hey, I don't really want to redact this, so I'm going to write it so I don't have to have this information there. So there are ways to accommodate that in some respects.
And what about doing the same for pro se litigants? Is that the kind of thing where we can guide how they write what their submissions are? Or is that not really?
I think that's a level of complexity and legal advice that the Resource Center couldn't really give.
Yeah,
We can't tell we can tell somebody how to do something, suggest a form to use, but we can't tell them what to do and what to put in it.
fair enough. Okay. Are there specific criteria or considerations for completely excluding certain case types from the database?
Yes.
What would that be like?
I know of 2 case types that have to be excluded completely by statute.
Are you able to say those?
Sure. Are concealed pistol licensing cases
Mm-hmm.
and gun registration cases. Those are excluded by statute.
Right.
And I do want to put a footnote in our Title 31 taxi cases. Those are, because we deal with those through ETIMs, and they go to ETIMs and we don't post them anywhere except to serve them. So those won't appear on our, and because we're working with our internal case management system vendor to create this system, and those aren't in this system, they won't appear in the database.
Do you think we should find a way to do that eventually?
Well, that's a sticky issue that we're trying to out right now.
Yeah, I'll be curious where you end up on it. I mean, it seems like either we're creating transparency or we're not. And
Mhm.
if certain cases are excluded, then that disadvantages the public. So we should, all right, I can't wait to hear. Yes. For the 2 case types that you mentioned are excluded, can you say why they're excluded?
It's statutory that they're confidential. I can't cite you the statute off the top.
No,
of my
that's
head.
okay. So that's local statute?
With a question mark, I'm pretty sure it's local statute. We can follow up with you.
Yeah, I'd be interested to know, as the author of the red flag law, whether or not that information could be useful to survivors, victims, those
Yeah.
who are filing TROs, et cetera.
Okay.
And can you give more detail on the features of the search function that is being developed for user friendliness and accessibility?
So it will allow individuals to search with a date range, with a judge, with a case type, and then they'll get a redacted order. At this time, and I want to sort of step back and say the larger picture, and I think you've heard this from me last year and this year, a lot of our technology is we start with square one.
Mm-hmm.
Once we get that, then we start evaluating how we can expand it. So right now, the way we're putting it together, it doesn't have Boolean search function. That doesn't mean it won't in the future.
Mm-hmm.
It's something that we're working on. We also will be able to search by property address and zip code. So there are a lot of elements to the search, and anything that meets the criteria in the search, the case will come up.
Great. And how are you engaging stakeholders during the development of the database?
Oh, that will happen in our testing function phase, pardon me.
So you don't think you need to do it as you're building?
We've heard from a lot of people what's necessary, and we know what the statute says in terms of what we have to provide.
Fair enough.
We're trying to meet those 2 things. And it is, I'm sorry, I can tell you affirmatively, it is the local statute on the guns.
Thank you.
You're welcome.
For the e-filing portal, how do you actively gather feedback on the functionality and user experience?
We solicit feedback in the Resource Center, and we also ask for feedback from the task force, from our stakeholders periodically.
Thank you. Which stakeholders do you mean when you say that?
Mostly it's the OLAN, legal aid stakeholders. We also reach out, if agencies hear from it, we've talked about it with, the OAH Advisory Committee.
And what training and support mechanisms do you have in place for users navigating the e-filing portal?
Users can access the e-filing portal through the portal landing page on the OAH website. The landing page features several guides for users to better understand how to utilize the portal. There's also a feature that guides users through a series of questions to help direct them to the most appropriate portal page. They can also contact the clerk's office or the Resource Center if they have any questions regarding the e-filing portal.
Could you provide a timeline or expected milestones for the development and implementation of public access to the case management system through the portal?
So we're currently working with the JTI, that's our vendor, the JTI implementation team on the final order search. We will conduct internal testing throughout the current quarter. And upon the launch of the final order search, we'll begin development of adding more features to the.
Okay, so you said, was this what you were talking about earlier, Q3?
Yes.
Okay.
Yeah.
Are there any security or privacy measures being implemented to safeguard sensitive case information while providing limited public access through the portal?
Yes, users must provide, and this is why users have to provide an email address, because
Mhm.
that means that email address is connected to the one in the case that they're associated with. And so users can only see the cases that their email address is associated with. That's the security protocol that we have, so that somebody can't accidentally access a confidential case. The authentication, I guess, is the word I was looking for, prevents users who aren't involved in a case from gaining access to the limited case information that's currently available.
Got it. How does OAH plan to improve data collection to distinguish between filings made via the e-filing portal, DPW, OAH interface, and other methods?
We're evaluating best ways to do that.
Okay.
I'm sorry, I don't have an answer for you.
No,
right
that's
now.
okay. I mean,
There are a lot of moving pieces in
try not to
technology
beat a
right
dead
now.
horse on some of this stuff, but obviously it's important.
Yes.
Okay, can you share any observations or trends in the types of cases or litigants that predominantly opt for paper filings?
My understanding is that predominantly paper filings are from some of the public benefits case types. And then the Title 31 taxi cases are, and then that's mostly in person. For USPS, the majority of what we see is actually people paying DPW fines by check.
Those go to you?
Some of them do.
Interesting.
Yeah. We would like to not do that.
Understood. That seems like something we could maybe sort out in this committee, given that we have both of you. Because you don't get that money, right?
No, it goes to the general fund.
Okay.
So we're basically a pass-through.
Okay.
Oh, and DPW does not take checks.
Oh,
At least that's what I think I know. I'll have to look into that.
yeah. We had their hearing yesterday, man. We could have gotten them on the hot seat. Okay. Why doesn't OAH track the number of video WebEx hearings and the number of in-person hearings requested by any party?
So the default setting for our WebEx hearings is audio only. Litigants have wide access to telephones to call into the WebEx hearings. At the ALJ's discretion, the ALJ may permit a hearing to be held by video, right? So we have those two types. They're all in WebEx. Our case management system does not differentiate between audio hearings or video hearings. Because they're scheduled in two different recording systems, we're able to distinguish in-person hearings versus WebEx hearings because they're in person, so they have to be scheduled in a courtroom, so they're scheduled differently. So we can distinguish between those, but we can't management system between the audio and the video hearings.
They're mostly just audio.
Right now, yes.
That's so interesting. It's not helpful to
And-
the ALJ to see people.
There is a large amount of debate between whether in order to weigh credibility, you actually need to, or whether that seeing somebody is giving you cues for credibility that aren't, somebody may be nervous in a hearing and be sweating when they're testifying. And not knowing that that person is nervous, you see somebody sweating and you go,
They're lying.
Yeah. So, justice is blind, right? So it's a balance.
I was gonna say that, but you beat me to it.
But yeah, it's also something that is, we continually evaluate. And the interesting thing is we do have some cases that are scheduled and the Title 31 hearings are scheduled in a way that the litigant can either join by clicking a link or calling in. And I don't know what the balance is between people calling in or clicking on the link and showing up by video. It would be interesting to try and figure that out, but I don't know that we can. My impression is that the majority of people call in even when they're given. So
That's so interesting. I just assumed it was mostly video because that's what WebEx mostly is, but now I know. Okay. All right. So we've talked about the Resource Center a bit today throughout our discussion and the different things that they're doing. They provide self-help materials for pro se litigants. They provide support for the portal. What else should we know about the Resource Center's services?
They provide guidance and resource to litigants, including unrepresented litigants and community, provide technical assistance with how to file cases and navigate through the OAH hearing process. And with the big caveat that we cannot provide legal advice. So those are sort of the big buckets.
You don't have a separate budget for the Resource Center. You're obviously dedicating resources there.
Yes.
How do you ensure that there's adequate resources?
Hi, we have dedicated staff to the Resource Center, and that's already included in our budget.
How do you gauge whether or not they are meeting all of the demands for their services?
We've started implementing, or our Legal Resource Center manager is starting to collect much more robust data to figure out where the need is and how to address that need. It's in progress, anew. So I think we'll need a year or two to figure out exactly where we're going to land. And that might shift depending on what types of cases we see, where there, if there's a surge in a type.
Or
of
how much
case.
more stuff is online?
Exactly.
It all goes together. Okay. In FY23 and FY24 to date, the Resource Center received approximately 3,960 calls and 555 emails. Are there specific trends or recurring themes in the types of assistance sought by individuals reaching out to the center?
I don't know the answer to that question, but we're happy to follow up on that.
Sure. Sounds like could be related to the manager's work that we just talked about.
Most
All
likely.
right, moving on to language access. Given the decrease in allocated budget for written translation from FY23 to FY24, what factors contributed to this change and how does it impact language access services?
So there actually wasn't a decrease.
Oh.
We forecast and budgeted for the same amount at the beginning of each fiscal year. And we monitor that as we go. And if we need more, then we reallocate funds to make sure.
Got it. And do you think the part-time allocation of staff is adequate at this time?
Yes, we meet or exceed our mandate with just a language access coordinator, but we also have a team of FTEs to support that individual's work as part of their duties.
How do you use the funds that you've set aside for written translation? Are there specific types of documents or languages that receive a larger share of the allocation?
I don't know the specific answer to that question, so I need to follow up with you.
Okay. All right. We have talked a bit already about how you're reassigning personnel to address backlogs. So we've talked about DOB. I think we talked about SNAP. Did we talk about SNAP? No, I guess we didn't talk about staffing. We just talked about,
Well, I talked about not necessarily reallocating staff, but managing those cases with having more people working on them. So, and I want to say that at this time, I wouldn't necessarily call the SNAP stuff backlog
Okay.
because we are managing as it comes in.
okay.
Really, we only have a backlog in the former DCRA cases and DPW, and we are working with staff to handle those matters in order to reduce the backlog. As I talked about with DCRA and the number of defaults that we have and bringing that number down in proportion with the number of cases we have. So it's really just those two jurisdictions.
Okay, then we've talked about it. All right. You talked about bringing in contractors to help with data entry and repetitive tasks. Do you bring contractors in for anything else? To help?
No.
Specifically related to backlogs, I would say.
Well, and that's the contractors are doing data entry for new cases to try and ensure that we don't have a backlog at the front end.
Yeah.
And then working to help support those FTEs who are managing the backlog on the back end as well. So at case initiation stage and case closure stage, everything in between is done by FTEs.
Mm-hmm. And what do you use to monitor and forecast caseloads?
So we have monthly analysis of caseload in each of our clusters in each jurisdiction. We weekly monitor changes in regulations and statutes that may impact OAH caseload, and annual communication with our sister agencies regarding the current caseload for that agency at the last 3, 4, 5 years, including the fiscal. These are what are called the 16E letters. And then also requesting information on what their expectations for caseload in the next fiscal year are. So we do it monthly, weekly, monthly, and annually.
Great. Are there any MOUs to aid in decreasing caseloads? No, you got to do it all. Okay. For sexual harassment complaints received in FY23 and 24, can you provide any additional details on the investigative process and what factors led to the determination the complaint was unsubstantiated?
OAH followed the investigative process in the applicable mayor's order. These are confidential matters and I can't.
Okay. In the event that both the primary and the alternate sexual harassment officers are unavailable, what contingency plans or protocols are in place to ensure the timely and effective handling of sexual harassment complaints?
If I understand the mayor's order, that individual can be referred to a sexual harassment officer in any agency.
You do understand it? Excellent. Sorry, we're working through this with all the agencies. All right, that is true. And there should be a list that staff have access to if needed.
Yep.
Okay, very good.
Yep.
How has the agency actively promoted racial equity within its policies and practices, and what steps are being taken to ensure equal access to hearings?
Well, our mission is to serve all district residents equally. I have to say that we have a very diverse staff and bench. In addition, we have worked to publicize our vacancies with traditionally underrepresented communities, such as publicizing ALJ vacancies in local affinity bar associations and working with historically Black college and university law schools to recruit judicial. Bringing a wide range of experience and perspectives to bear allows judges to make better informed decisions and increases public confidence in them.
Excellent. Anything else you want to add?
I don't think
I
so.
think we've talked about everything three
think
different
so.
ways at this point, so we can wrap it up. Okay, very good. Well, this concludes today's public oversight hearing. If you plan on submitting written testimony for the record, please do so by going to the council hearing management system at lims.dccouncil.gov/hearings. The record will close on February 23rd at 5:30 p.m. I'd like to take a moment to remind everyone the Committee on Public Works and Operations will be holding more performance oversight hearings in the coming weeks. Please visit the council hearing management system for the committee's performance oversight hearings schedule. If you would like to testify at any of these hearings, you can sign up on the council hearing management system at lims.dccouncil.gov/hearings. The time is 4:35 p.m. and this hearing is adjourned.
Thank you, Chairperson. Are we off? Good job. Thank you.
You did it.
Yeah, this was.
Oh, you did. Oh, you did it. And plus, I learned a lot. You see all my notes. So, yeah.